Muy buenas tardes, soy Arturo Fontaine.
I am Arturo Fontaine, and I would like to welcome you to this conversation. Our guest this afternoon is the distinguished professor Kim Scheppele from Princeton University. If you prefer to follow her presentation in English, you can do that by going to the uai.cl website. It is not necessary to enroll. It's a live streaming. So if you want to hear in English, go to that URL that I have just given you. Now, days away from the inauguration of the first democratically elected constitutional convention in our history, it is appropriate to recall these words from Edmund Burke. As we all know, Burke says, "The machinery of a free constitution is no simple thing, but as intricate and delicate as it is valuable. A constitution with balanced powers is always to be the critical question." That's the quote. President Eduardo Frei Montalva, in his message when he created the first constitutional court in our history in 1970, stated that, and I quote, "Many of the conflicts that create a crisis between the public powers are born of differences on interpretation on constitutional texts." The creation of the Constitutional Court was born to foresee and avoid these conflicts and conferred to the court, among other attributions, those of, let me quote, "resolving questions on constitutionality that arise during the processing of bills and matters that arise on the constitutionality of a decree with the force of law." It was then, in 1970, that both the constitutional control by a special court and the now much discussed preventive control, the review of the constitutionality of bills of law by that constitutional court. That's when, as they are bills and not passed laws. President Eduardo Frei Montalva mentioned the French Constitutional Court, which seems to have been the model. President Frei stated that this was intended to avoid conflicts that could threaten the normal development of our democratic regime. The court was redefined in the 1980 Constitution and reformed in 2005. However, the main attributions of the original 1970 court are still in force. The issue that brings us together today is, in general, what role do constitutional courts play in contemporary democracies and why? Are they really necessary or not? Is it not better that this task be carried out by a chamber or one of the chambers in the Supreme Court? Should it not be the Congress itself that decides whether it's bills and therefore the law it passes are or not constitutional? Is it not anti-democratic for a group of judges to invalidate a bill, a law that has been passed by Parliament as unconstitutional? Are not such decisions inevitably political and transform the Constitutional Court into a third political chamber? On the other hand, if in the future the very president, the very parliaments who promote a bill are the ones who judge on the constitutionality of that bill, does not a conflict of interest arise? Will they not tend to interpret the Constitution in such a way that their bill is compatible with it? Who should judge whether a law, a decree, contradicts or not the Constitution? If there is no court dedicated to this task, might not the rights guaranteed by the Constitution be liquefied to the point of meaning almost nothing? Is a constitution without borders still the constitution approved by the Constituent Convention and ratified by the people in a referendum? Might not future laws and decrees denaturalize it completely? What has been the experience of other countries with their constitutional courts? What can we learn from those experiences? These are the issues that the Constitutional Convention will have to analyze, discuss, debate, and decide upon. It is difficult to imagine a more appropriate and prestigious international expert to guide us in these matters than Professor Kim Scheppele. Kim Scheppele is a professor of sociology and international affairs in the School of International Affairs at Princeton University. She was the founding director of the gender program at the Central European University in Budapest, directed the law and the International Affairs program at Princeton University. She's a former president of the Law and Society Association. She is currently a member of the Executive Committee of the International Association of Constitutional Law. She is currently a member of the Executive Committee and has first-hand knowledge of the workings of the Hungarian Constitutional Court, for example. Among her numerous publications, they address probably the greatest danger to contemporary democracies. And it is not really the military uniform or brute dictatorship, but rather something that's more sophisticated and subtle, what she calls legal authoritarianism. She has also spoken about constitutional coup d'etats. Kim Scheppele has illuminated with extraordinary precision and depth the nature of this political phenomenon of our time. I was deeply impressed by a lecture she gave on the subject at the Diego Portales University some 4 or 5 years ago. She was invited by Javier Couso, who is with us today. And since then, I read everything she publishes. In my last book, The Questions of the Political Regime, one can recognize the influence of her way of looking at these phenomena in our time. Legal authoritarianism. These are rulers who, supported by electoral triumphs, succeed in getting the parliament, which is favorable to them, to introduce legal and constitutional changes that allow them to merge the powers in their hands. Then what Burke considered to be critical issue is dismantled, a constitution with balanced powers. The checks and balances disappear. The phenomenon is happening in very different countries and cultures. Putin in Russia, Orbán in Hungary, Chavez in Venezuela, Ortega in Nicaragua, Kaczynski in Poland, Erdogan in Turkey. And they still respect the legal democratic formalities. But the power of the constitutional court, of the judiciary, of the electoral court, of the media has fallen into their hands. They often use referendums and plebiscites and popular consultations, as Orbán does, to validate their policies. The opponents have very little chance of coming to power. In this way, they install, quote unquote, democratic legal dictators. What roles do or can constitutional courts play in these cases? Why, in Hungary and Poland, did constitutional courts stand up to the authoritarianism by Orbán and Kaczynski? The topic that Kim Scheppele will address today is precisely constitutional courts as defenders of democracy. Addressing this issue could not be more relevant when it comes to drafting in our times a democratic constitution. So we have with us today also Javier Couso, professor from Universidad Diego Portales and from the University of Utrecht from the Netherlands. I would like to remind you, if you want to follow the conversation or the presentation in English, go to www.uai.cl. It's a live stream directly in English, uai.cl. Professor Scheppele, you have the floors, we're all ears.
Thank you so much. And I'm sorry for not speaking Spanish, but I will try to speak English slowly so that the interpreters can keep up. I'm really delighted and honored to be here because this is a particular moment in Chile's history, and I'm very glad to participate in the conversation. So I'm going to share some slides with you and hope that you can see them. And I hope also the slides help for everyone who is following along in English, because I'm afraid the slides are in English also. So I want to talk today about constitutional courts as defenders of democracy. And the occasion for doing this, of course, is that Chile is in the middle of debating a new constitution. And one of the live questions is what to do with the Constitutional Court. So the question is, should this new constitution include a constitutional court? And should it look the same as the constitutional court that Chile presently has? Now, this is going to be something decided by the Constituent Assembly. And what I hope to do in the lecture today is to give a sense of how constitutional courts have acted elsewhere in the world and some of the dangers that can come about when they're captured and how you can defend against that. So my argument today is going to be that constitutional courts can be very important defenders of democracy. And I saw this at close range because in the 1990s, I worked for 4 years at the Constitutional Court of Hungary, which, as you can see in the building on the left, is one of the ugliest buildings on earth. And then I had a chance to work for a year in 2003 at the Constitutional Court of Russia. Actually, before it moved to this grand building, it had a rather nondescript building in the middle of Moscow at that time. But working inside these courts, I got a chance to see how they operate from the inside. And I did a lot of work as a sociologist as well to figure out how they were seen from the outside. And so a lot of my work is based on that experience and what's happened to those courts. So my talk today will be in 3 parts. So first, I want to ask the question, why have countries created constitutional courts? And this will be a little bit of a history with some particular lessons from post-communist Europe. The second part will address, so what should constitutional courts do? It turns out they do a lot of different things. And so there are choices about whether a constitutional court should do one thing or another. And then part 3 is how to ensure that a new constitution, how a new constitution can ensure that a constitutional court is resilient when it's attacked. And this is where I'll talk about some cautionary tales with potential solutions. So let me start with creating constitutional courts. So the first constitutional court was in Austria in 1920. It was the brainchild of Hans Kelsen, who was a famous legal philosopher. And the important thing about this court is when it was created, 1920. So Austria, the Austro-Hungarian Empire, had lost World War I, and it had been dismembered. Austria was a tiny state compared to what it had been used to, and it was trying to create a republic for the first time. So the question that arose, and the question that very often arises when constitutional courts have been created, is how do we completely change our form of government and ensure that all of the institutions created by that government behave within the limits of the Constitution? So Kelsen's Constitutional Court was charged with ensuring that all the institutions functioned as the Constitution required. And there was no rights jurisdiction because the Austrian Constitution didn't have a Bill of Rights. In fact, many constitutions of that era didn't have bills of rights. So the first constitutional court was created just to enforce the structural provisions of the Austrian Constitution. Now, the Constitutional Court was revolutionary because it separated out a constitutional court, a specialized court, from the ordinary judiciary. And this court was organized very differently. It had fixed terms of office for judges rather than having, say, a civil service model of judges. It had a more political appointment process, so not just controlled by judges, but also enmeshed in political nominations. And it also had a limited jurisdiction, constitutional questions alone. So in this respect, it was not really part of the ordinary judiciary. What was distinctive about this model was that it concentrated review, constitutional review, in one court. And that was quite different than the main constitutional model that was available, which was the American one, in which any court can assess the constitutionality of laws. The idea here was to put it in one court so that it was always very clear what laws were constitutional and what laws were not for the whole country at the same time. Now, also the Constitutional Court provided a way for civil law countries like Austria, like Chile for that matter, like every place in the world that Britain did not colonize, all the civil law jurisdictions usually do not permit judges to make law with their decisions. Judicial decisions are simply not a source of law. But the Constitutional Court, in places where it exists, can be a binding source of law, and its cases constitute that law. So it operates very differently from ordinary courts in that respect also. And perhaps this is why almost all the jurisdictions with constitutional courts are civil law systems where the ordinary judiciary is not empowered in that way. So this institution was slow to catch on. So Austria invents it and everybody else pays no attention until the Second World War. And then after the Second World War, as many countries emerged from autocracy, from military defeat, from reorganizations of their governments following a trauma, a number of different countries began to adopt these constitutional courts because they adopted new constitutions and were really making a transition to a democratic and government for the first time in many ways. So after World War I, constitutions started including bills of rights routinely, and because constitutional courts were being created in those same constitutions, the post-World War II constitutions basically gave the constitutional courts jurisdiction over both structures, keeping the structures the way they're supposed to be in the Constitution, and also over rights. And the phrase at the time was that the constitutional courts would be guardians of the Constitution. So by now, this is a list, I think it's a complete list of all the countries that have constitutional courts, which is to say there are a lot of them around the world. They're not all so effective, like I wouldn't really take the one in Uzbekistan to be a model, for example. But a lot of these really have developed important jurisprudence and have really built an important role for themselves in their respective governments. So then the question is sort of why invent them? And at the time that most of these courts were invented, and I think even now, experience shows that courts are better defenders of constitutions than either the executive or the parliament. The executive is not a good defender of the Constitution because very often it's the executive that the Constitution has to protect you from. In fact, the point of having a government of separated powers or of checks and balances is precisely so the executive doesn't concentrate all powers in their hands. So you don't want the executive enforcing the Constitution. And the problem with placing this in the hands of the parliament is that the parliament is often too large a body, too diffuse a body, too polarized a body to settle on the meaning of a constitutional text. So constitutional courts often have turned out to be a very good guardian of the Constitution as written, and particularly when you have a democratic process, as Chile is now going through, with a constituent assembly that has been elected. That process is democratic, and to preserve what it produces, you need someone to guard it that isn't itself buffeted around by immediate democratic responsiveness. You want an institution that's loyal to this Constitution that's democratically produced. So constitutional courts are often superimposed over a judiciary that is accustomed to operating under different rules. When you get a new constitution, the ordinary judiciary has to find a way to adjust. You don't just suddenly get a new judiciary, usually with a new constitution. But very often you do get a new constitutional court or a newly reconstituted constitutional court. And its job is to ensure that everybody understands this new constitution and actually follows it. Constitutional courts are often really useful when you get a new constitution, because in the transition from an old to a new constitution, it may be the case that suddenly a lot of the old laws have become unconstitutional. One of the reasons for changing the Constitution is often to change the direction of the country, and then it's not surprising if a lot of the old laws become unconstitutional when the new Constitution is enacted, and a constitutional court can help to sort of clear out all those old laws and check them against the new Constitution. And finally, constitutional courts, even though the judges are not typically directly elected, very often are defenders of democracy because they preserve a democratic balance between citizens and political institutions. They do this by enforcing rights, and they also do this by enforcing a democratically constructed constitution. So this is one reason why constitutional courts have become very popular. Now, why create or keep a constitutional court instead of just having a Supreme Court? So a criticism of constitutional courts is that they're very political and that they might block change of a newly elected government, for example. But actually, constitutional courts, because their judges typically have fixed terms of office, 9 years, 12 years, usually not renewable, the judges on the Constitutional Court will turn over a little more slowly than governments, but a lot faster than a Supreme Court. So in many ways, the constitutional courts will be more responsive to long-term democratic change than a Supreme Court would. And as I've mentioned before, constitutional courts can create binding case law, which is usually not possible otherwise in a civil law system. Constitutional courts also, especially if they're newly created, newly reconstituted, or working with a new constitution, can provide the pivot point around which all the constitutional change in the new government can be assessed. So it can be an institution that is refreshed more easily than the ordinary courts. Now, in the post-communist world, every single country that came out from under the Soviet Union, both the Soviet Union and its satellite states, adopted constitutional courts with varying success. And what was, I think, most important in that transition was that these constitutional courts, where they worked, really set down roots and created democracies. And where they failed, democracy failed too. So what you see, and I remember interviewing people in Hungary in the 1990s and asked them, don't you think the Constitutional Court is undemocratic? And the response that I got actually very often was, no, we know we have a democracy when we have a constitutional court, right? When the political leaders respect it and honor it, we know they're respecting the Constitution that protects us too. So the constitutional courts can also provide an avenue for citizen participation if the government can be challenged in the Constitutional Court for violating the new Constitution. So that experience, I think, in the places where it worked really generated a lot of support for constitutional courts. So when the constitutional courts of Hungary and Poland came under attack recently in the last 10 years, what you saw were sort of mass demonstrations supporting the constitutional courts. On the left was a sit-in, an all-night sit-in at the Constitutional Court in Hungary in 2013. At the right was one of many mass demonstrations that happened in Poland as the Constitutional Court was being captured. And we've seen this in other places, in places as far-flung as Egypt and as Pakistan. People came to the streets when the Constitutional Court or the court with constitutional jurisdiction came under attack. I think publics who get used to these, when they're functioning properly, recognize them as guardians of democracy. So then let me say, so if you're going to have a constitutional court, what should it do? And constitutional courts do a whole bunch of different things, but probably the most important thing constitutional courts do is to nullify unconstitutional laws. Now, virtually all constitutional courts have the power to nullify laws, And we'll talk in a minute about when they do that, whether it's before they're enacted or after. But almost all constitutional courts have the power, even the French court now, to review the constitutionality of laws after they've been enacted. And this can come about in two different ways. One is that the courts can have the power of what's called abstract review, which is a judicial case that emerges without facts of a particular dispute. It's what we call a facial challenge. You just look at the surface of the law and the surface of the Constitution and check them for compatibility. In many countries, these facial challenges can be brought by certain particular political actors, like the president, or like 1/4 of the parliament, for example, or an ombudsman, or affected states in a federal system, or others. So oftentimes abstract review is given to particular bodies. But when I worked at the Hungarian Constitutional Court, they used this really unusual experiment of what was called the actio popularis, which meant that anybody, not just any citizen, like anyone in the world, could take a case to the Constitutional Court of Hungary saying, this law on the books is unconstitutional, discuss, and the court would have to answer those questions. You would think that would have generated a completely unmanageable caseload, but it turns out the number of cases you get is not the number of people there are, but it's the number of laws there are, actually. And the Constitutional Court of Hungary was issuing 500, 600, 700 decisions a year in those early years. And what you could see was that ordinary people would bring these cases and say, this law doesn't look right to me. And it was a way of generating a kind of citizen education in the country that made the Constitutional Court really immensely popular during those years. Now, that's abstract review, sort of these facial challenges. What's often another thing that constitutional courts can do is to be asked to review laws in the context of concrete cases. So sometimes a law that one of the parties or many people believe is unconstitutional has to be applied in a concrete case. And there are ways to appeal. When the losing party appeals, a case can come through the ordinary courts to the Constitutional Court as a sort of appeal, an extra appeals process. These are typically called constitutional complaints. They're usually used only in cases involving individual violations of rights. But for example, the German Federal Constitutional Court, most of their case law is based out of these concrete constitutional complaints. But there's another mechanism that can get concrete cases to constitutional courts. And that's when a judge has a statute before him, a law before him or her. And the judge looks at this and says, I'm not so sure about this. Or one of the parties says, I don't think this law is constitutional. And the judge who has the case before her stops the proceedings and sends the question to the Constitutional Court for an answer, and just holds everything in place until the Constitutional Court comes back and says, is this law unconstitutional, or does it have to be interpreted in a particular way? And that way there's a kind of dialogue that emerges between the ordinary judges and the judges of the Constitutional Court. That's also a quite common procedure in many jurisdictions. Now, what are the effects if the court declares a law unconstitutional? Well, in many cases, the law just is immediately voided. It's as if the law never existed. And here too, there's a choice. So is the law voided the minute the court says so? Or can it be voided retrospectively? In cases, particularly where you have a criminal law that's been found unconstitutional, courts will often say, well, everybody convicted under this law has to be let out of prison, for example. So there may be retroactive effects, very unusual, but in criminal cases sometimes. Courts also use this possibility of what is called prospective overruling, which is where the law is voided at some date in the future. So a court will say, this law is unconstitutional, but to just nullify it now would leave a gap in the law, and it's better to have something in that space than nothing. So we'll give the parliament a year to fix it. And if they don't fix it in a year, then the law is nullified. So that's something else courts can do to avoid a kind of chaos from just nullifying law immediately. And sometimes, depending on the powers of a court, a law can be nullified conditionally, right? It can be nullified until such time as other political actors override them. So there are some systems like Canada, for example, which doesn't have a constitutional court, but it has a Supreme Court. And the UK has a bit of a similar sort of system, where if the court declares that that a law is unconstitutional or incompatible, there's different things in different jurisdictions, then either it has to wait for parliamentary confirmation before the law is nullified, or the parliament can override the decision of the court by saying, we recognize that the court has said this is unconstitutional, but we're going to do it anyway, right? So in other words, there's like a second stage. And sometimes, so that's one way, if court makes a decision and then there's a parliamentary process that needs to confirm it before the law is nullified. Sometimes, and this is where I think constitutional drafters often don't give enough attention to this, if a court decision nullifies a law, declares a law passed by the parliament unconstitutional, another way to change the decision of the court is, of course, to amend the Constitution. So this is where it may make sense to think about how easy is it to amend the Constitution. And if you have a court that has a lot of power and a constitution that's really hard to amend, this is a recipe for crisis. This is the problem with the US right now. And we're so polarized over our Supreme Court. It's very difficult to change a decision of the Supreme Court. So the court itself gets attacked. So if the court's going to be very strong, it might make sense to have an easier amendment process and to think about those things together. So the importance of nullification in constitutional renewal is that, again, when a new constitution comes in, it may make a lot of laws unconstitutional at once. And this is where, if you have one body dedicated to that cleanup, it can actually make things a lot easier. And it suggests that there might be a possibility of making access to the court easy, especially in the first few years, so that this constitutional cleanup can actually be accomplished more quickly than it might otherwise be. So all of that is about nullification of laws, which is the main thing a constitutional court does. But sometimes a constitutional court doesn't nullify the laws, but it says the Constitution requires that the law be understood in a certain way. And so what it means is that if the law is read in a different way, then it would be unconstitutional. But as long as other judges and institutions of state read the decision this way, then it's permissible, right? So what this can do is the court can either create new constitutional conditions or can do what gets called, actually in the common law world, reading down, sort of narrowing what a broad phrase could mean to something that's constitutional. So for example, the German Constitutional Court recently had a case where the German parliament passed a law that allowed all the intelligence services and the police to share information. And the Constitutional Court said, now wait a second, there are different constitutional constraints on the police and on the intelligence services. This law cannot be used to circumvent those constraints. So the court, in a sense, added a condition to the law and then said, you can share information as long as no one is circumventing the constraints that apply to their specific body, right? So the court just added that in some sense to the statute by interpretation and made that the only way the statute was legal. So the statute stands, but sort of as amended by the Constitutional Court. Now, here's where we get to the issue in Chile. So one thing some constitutional courts do is that they provide guidance for other institutions. So the French model of constitutional review was for a long time this model that Chile had adopted, which is that the court gets a chance to look at a law before the parliament passes it. And that sort of inserts the constitutional court into the legislative process. Now, what's interesting to me, and this was the court I worked in Hungary, it had that power and it refused to do it. It literally said, it's unconstitutional for us to do that because it mixes up separation of powers. It puts the court directly into the legislative process, and we're going to wait till you're done. So my court in Hungary refused to do that, even though it was part of its jurisdiction. And I think what you see in a lot of other countries is that rather than have the Constitutional Court get involved at that stage, the other kind of option is to create a parliamentary constitutional committee whose job it is to review the constitutionality of legislation within the parliament, sort of in the parliamentary process, but to leave the Constitutional Court out of it, because all the controversies that have arisen in Chile tend to arise in these systems where courts have a priori review, right? So there's another place where the Constitutional Court can insert itself, and that is when the parliament passes something, often there's a president who must sign it. And the president may or may not have initiated that law. So one of the things you see sometimes is that the president can send a law over to the Constitutional Court to check it out, see if it's constitutional before the president signs it. And this works best where you have, like in Hungary or like in Germany, where the person who must sign it is kind of more of a figurehead than the head of state, than the actual head of the government, so to speak. And so in this case, then there's a kind of check, right, that the president who swears an oath to the Constitution makes sure the law is constitutional before signing it. And that's something else that you see in a number of constitutional systems. But here too, I always want to say this is also a separation of powers question. And maybe this is a role for a justice ministry advising the executive branch on the constitutionality of legislation. Again, to get the court out of the separation of powers problem and assign it to somebody in that branch. So the other thing courts can do is when they get a law after it's already gone into effect, when they strike a law down, courts will very often say, if you do the following things, then it would be constitutional, right? So that's something that courts do often, and that actually is a important function of courts, but it's also something that law professors do, right? Like this law wasn't any good, so what would actually meet constitutional criteria? This is something where others can fill in too. What else? Constitutional courts just can correct the mistakes of ordinary courts, and I've mentioned already that a number of courts have this jurisdiction of what are called constitutional complaints. So that's where individuals who feel like their rights have been violated, but the ordinary courts have not recognized this, can go to the court, Constitutional Court as a last resort. These cases usually fail, at least if your judiciary is doing its job, because if the person's lost in every other court, probably they should lose at the Constitutional Court too, but it's an important check on the ordinary judiciary for the Constitutional Court to have that power. A more controversial power Constitutional courts sometimes have is to supervise the electoral process. Now, you often see, this is something you see, for example, in Germany, that courts have the power to regulate political parties. Sometimes they can ban anti-constitutional parties. They're often charged with enforcing the laws about the operation of political parties. In a number of countries, they resolve election law disputes. They must certify elections. They have to rule on interpretation of election laws during an election season. Sometimes also courts are charged with impeachments, like removals of elected officials from office. And so in that sense, they don't preside over getting them into power, they preside over getting them out of power. And here too, the courts that do this wind up in a lot of very, tough political controversies. And what I always want to say is, wouldn't this be better done by an independent electoral commission or some other body that is specialized, with that task, rather than giving it to the Constitutional Court? But again, many constitutional courts have that power. And so what this suggests, and this is kind of one of my big messages for today in constitutional drafting, is that if you want to defend a constitution, it would be a very good idea, I think, to have a constitutional court. But it's also a very good idea not to give the Constitutional Court too many things to do. And so this is where it's good to think about redundancy, right? About about creating many institutions, many offices throughout the government whose job it is to check the constitutionality of laws and to check that government agencies are operating within their constitutional boundaries. So I've already mentioned most of these: a constitutional committee of the parliament to assess the constitutionality of lawmaking, a justice ministry division to check the constitutionality of executive decrees, and so on. The ordinary judiciary should be constantly looking for constitutional issues, right? Both to refer them to the Constitutional Court, but also to enforce Constitutional Court's decisions. There could be ombuds offices, ombudsmen, who actually can resolve human rights questions more quickly than courts. That would be another supplement. In the US, we have things called inspector generals. These are people in important federal agencies who have the power to investigate corruption and unconstitutionality within the agency. And then other specialized institutions like independent election commissions. The reason for having all of those is that if one of them fails, the others are backups. And if you really want to enforce a constitution, you may need not to put everything on the shoulders of the Constitutional Court, but to spread these things out. And so my last section. So how do you defend a new constitution with resilience? You know, how do you keep a new constitution, or how do you get it to be real when it starts off just as a piece of paper, right? And I've already suggested some things, which is duplication. But this is where I want to give you a little bit of a cautionary tale. And so, like I said, I mostly work in Eastern Europe. And there we have two governments that are really quickly becoming non-democracies. In fact, Hungary last year was classified by the Varieties of Democracy Project. It's a political science sort of ratings agency. Hungary was already classified as a, quote, competitive authoritarian regime. Inside the EU, which everybody thought was going to keep states from going in that direction, and Poland is quickly following suit. And so these autocrats, and this is what's happening, you see it in Latin America as well, right? You see it in Venezuela, you're seeing it now in Peru, right? The current crisis. And there was a real moment of danger in Ecuador. So it's happening really all over the world, where these new autocrats come to power in elections, excuse me, and they use their electoral victory to change the constitutional system and redesign constitutional institutions. What's interesting now is that the old-fashioned military coup is out and change by fancy lawyer is in. Okay, and so as a result, what you're seeing is a lot of constitutional change and a lot of attacks on constitutional courts, because of course, constitutional courts are the front line of defense for the existing constitution. And as soon as these autocrats come to power, the first thing they want to do is get rid of that first line of defense. So in Hungary in 2010, Viktor Orban and his Fidesz political party won 2/3 of the seats in the parliament with only 53% of the votes. Sorry, that's all in Hungarian. But he inherited a system in which a single 2/3 vote of the parliament could change anything in the constitution. And that was an amendment rule that was just too easy, given the way the party system was organized. And so Viktor Orban launched a constitutional coup. With his majority, he quickly enacted a new constitution, marginalizing every other party in the parliament. He changed more than 800 laws in the first couple of years, and actually he's changed a lot more since then. And actually on Tuesday, the parliament passed about 1,000 pages of new laws that I'm working my way through, because he does that every once in a while. And so there's this constant legal change. Now, in order to do this, he had to kill off the Constitutional Court, that court that I felt very attached to because I worked there for 4 years. And so what he did was he neutralized the Constitutional Court first. So what did he do? Well, with his 2/3 majority, he amended the Constitution to change the procedure for electing judges. It used to be that you needed a majority of parliamentary parties to get a judicial nomination on the table, and then you needed 2/3 of the votes of members of parliament to elect a judge. And all they did was eliminate the first stage, and Orban's 2/3 elected new judges. Then he said, we need more judges on the court because we're suddenly going to give them a new competency, constitutional complaints, which they'd never had before. And so you could imagine that was going to flood the court with a lot of cases. And so he said, well, if they're going to get all those cases because we want to defend the court, we have to increase the number of judges. And he increased the number of judges by just enough so that with the retirements that were coming up, he was able to get a majority on that court within 3 years. And so by 2013, the court was packed with people who were from his political party and who have since that time almost always ruled for the government. But that wasn't enough because he was afraid maybe that some of them wouldn't be loyal. So he got rid of this abstract review. He got rid of the Actio Popularis petition where anybody could challenge a law and substituted these constitutional complaints, which are very important to the individuals involved. But constitutional complaints are very difficult levers to use to really change the whole system. And so, the Constitutional Court was rebelling, by the way, as it was being packed. And they made this amendment to their new constitution took effect in 2012. 2013, they amended it and said the entire past jurisprudence of the Constitutional Court is hereby nullified because it's from the old Constitution. And all the laws that the Constitutional Court has declared unconstitutional while we've been packing that court have now been added directly to the Constitution itself. So this really marked the end of the whole process. And again, it came from the fact that by having a constitutional majority, they were above the law. And so they did this. Now, in Poland, there was a similar kind of problem. But here in 2015, with less than half the vote, it's called Peace Party, the Law and Justice Party, won a majority of seats in both houses of parliament, and they won the presidency. They did not have a constitutional majority, so they could not amend the Constitution. So what were they going to do? They attacked the Constitutional Tribunal because it was the main body that could tell them no. So there's a complicated story. I'm not going to go through everything on this slide, but the battle came over the choice of judges. The outgoing government made a constitutional mistake by trying to grab a couple of the judges and elect them as, to try to prevent the peace government from electing them. The peace government didn't recognize any of the judges the outgoing government had nominated. And so as a result, the Constitutional Court was called in to decide on its own membership. And when it decided, pretty much obviously according to what the Constitution said, the government refused to publish or obey any of the decisions. And all they had to do was to wait out the retirement of this guy, the guy in the red picture here, who was the one holding the fort and refusing to seat the illegally appointed judges. But just by sort of bad luck, he retired the next year. And as soon as he retired, they were able to put in a new court president who seated all the illegally elected judges. And the Constitutional Court has never again challenged the government. So the personnel are really crucial to all of this. And so I just want to say that from looking at a couple of constitutional courts that were captured, that as you think about whether to have a constitutional court and what it should do, there's, I think, some lessons to be learned from this. So the first thing I think you need to do is to think about how to make the courts less susceptible to partisan takeover. Right. And the way to do that is to have a judicial selection process that ensures that all the political parties have some say. One-party judges are always a bad idea. And so you need a process that ensures that multiple parties will be involved. It also helps to have multiple stakeholders. So professional assessments, the Bar Association, other judges' assessments, different nominators for different seats, as you presently have, for example, in Chile, or nomination by one branch followed by a confirmation by another branch, something that kind of spreads out the nominations so that there isn't one actor that can just name all of the judges. It also helps to set judicial qualifications to maximize neutrality. So it's a common practice in many constitutional courts to have credentials that are more rigid or stricter than for ordinary judges. So for example, in Hungary, where I worked, judges had to have not just a law degree, but they had to have either a PhD in law, or they had to have 20 years of judicial experience before they could be named to the Constitutional Court. So something like that, where you have a track record that you can see before somebody can be named to the court, is very often a kind of protection. So you understand who you're getting. And then you need to regulate conflicts of interest. So judges shouldn't be party members. They shouldn't have come straight out of a prosecution office affiliated with the government. They shouldn't have just been in a ministry where they have a loyalty to a particular kind of branch. And so all of that, I think, matters. And then this is just what I've been saying all along, which is, and you need other institutions that do some of the work of the Constitutional Court. So if the court is captured, you still need the Parliamentary Constitutional Committee or the Justice Ministry offices or independent assessors or other independent bodies, election commissions, ombudspeople, NGOs, watchdogs, who can also do the work of the Constitutional Court. Because once you lose the Constitutional Court, if it's captured, if there aren't redundant institutions, then the whole system really can crumble. So you have to think about how to build in redundancies. And so constitutional courts can defend democracy, but Democrats also have to defend constitutional courts. And what we've seen in some of these places, in Poland in particular, there have just been these mass demonstrations as people have gone to the streets to defend their judiciaries. And that really is something that a democratic citizenry has to be prepared to do. And so I'll end here. You know, this is now, you're right on the edge of a new constitution. You have a democratically elected constituent assembly and a chance to rethink, once this constitution is written, how it should be defended. And so I'm really eager to see all of your choices. And I hope that this was helpful in at least framing what the issues are. So thanks very much.
Muchísimas gracias, Kim Scheppele, por esa brillante y completa.
Thank you so much, Kim, for that brilliant and very thorough presentation.
Presentación. Vamos a conversar ahora con.
Let us now have a conversation
Javier Couso,
with Javier Couso. I would like to offer the floor for Javier.
For this wonderful.
Voy a hablar en castellano, Javier.
Okay. Bueno, gracias, Kim.
Okay, so if I can speak in Spanish, I will do so. We've been working together for quite some time. You've been working in these topics for a long time, and it's unbelievable to see that in such a short period, in such a short presentation, you've been able to address all of the main topics. My comments, which basically are some questions that are important, that can be useful for Chileans that are part of the process, have to do with realities that are actually quite local or regional, maybe within Latin America. That suggests that a constitutional court, like I have said in other places, are not neither necessary nor enough conditions to have a constitutional democracy. So basically, Uruguay and Costa Rica, for example, which are the most consolidated democracies in the region, and Chile was too until October 2019. It was considered one of the three. It was that the three-party, three countries in all the standards, international transparency or Freedom House, declared these three countries good performers. In particular, Uruguay. It doesn't really even have a constitutional commission or room or chamber within the Supreme Court. It's a very democratic society, and it's a little bit like the New Zealanders. It's part of the culture. Like in New Zealand, they don't have a constitutional court, not even a Supreme Court, like they do in the US. Yet, consistently, they show respect for bills of rights. I'm just setting up the context because there are many other countries that have a constitutional courts in Latin America, Supreme Courts too, that have a lot of power to review the legal decisions, yet they have failed, like many of the post-Soviet countries that you have mentioned. So the first question is related to that. So under which conditions, different to the ones that you have already mentioned, that have to do with constitutional engineering, how the judges are appointed. So under which cultural or political culture, when we have all of these constitutional machinery, Ginsburg, Hack, Levinsky have all mentioned that there are certain unwritten regulations. This is something that Burke would have loved. Certain traditions that are particular to those countries that could depict the success of the court. To put it in other words, there doesn't seem to be constitutional engineering that can resist when a charismatic leader takes advantage of the moment when they have an important majority, like you have mentioned in Hungary or Poland. We can also recall the case of Russia, where the first constitutional court in Russia was basically eliminated, removed by a leader who supposedly was a liberal, according to the Western world. So that's the first consideration. And then the second thing is just to try and provoke a conversation here, has to do with a little bit of a paradox, but which is still crucial. The whole idea behind a constitutional court is that the government, and in particular the judiciary, because it's the law that is annulled when it's not constitutional, supposes that it is very clear that the legislator and their government are violating the Constitution. And that gives us to that awful world of interpretation of the laws. That is to say, it assumes that one can interpret that the Constitution is being infringed. So only when those are evident should they go to the Constitutional Court, especially when there's a rule, for example, regarding the competence. Is a clear rule, a quorum, or one of those rules. Yet a constitutional court, like maybe Kelser thought back in his days, should not refrain from making these certain decisions. A very concrete example, let me give you, with this I will end. The autonomy or the principle of human dignity, let's talk about that. It doesn't really matter whether the judges have a PhD or they've been judges for 20 years in a Supreme Court. If they have been educated or if they are, let's say, Islamic fundamentalists, I would most certainly not want them to be sitting and ruling over human dignity. There are other fundamentalisms. In Chile, for example, the Catholic, where you know the outcome ahead of time. When there's a law, for example, like on euthanasia, for me, it's actually the most consistent law, the most consistent bill when it comes to human dignity. But for other people, maybe they've got a PhD or more than 20 years, it's absolutely against human dignity. So the problem with these cases is that it creates the idea that important things are decided in a space where it should not necessarily be. And we spend a lot of social and political capital there. The most interesting case is a court that is not particularly different, like the one in Colombia, but it has gained the respect of Colombians and actually a large part of the world when they prohibited the re-election of a charismatic leader who wanted to carry on and remain in power. So even though that was a little bit of an activist decision because it declared a constitutional reform as unconstitutional, which is actually quite complex in our tradition, but still, it seemed that it was an infringement of democratic principles. Things like what agrees with human dignity, with human autonomy, abortion, free abortion, euthanasia, equalitarian marriage between same-sex people, where it doesn't really matter how many PhDs you have and how many years you've been a part of the Supreme Court, or the political philosophy or personal philosophy is actually going to be what makes the decision. When there are decisions that are divided, let's say 5-4, 10-11, when the court is split in some of these icon cases, in debatable topics, it's not very useful for a constitutional court for those gross infringements to the democratic and constitutional order, where the constitutional court should actually begin these democracies. So those are some of my thoughts, just to provoke the debate. Kim, the floor is yours.
Yes, well, thank you. And first of all, it's wonderful to be able to debate you, Javier. I've learned a lot from reading your work, including your work on Chile, but about so many things. So it's fabulous to be in a conversation with you about this. And you've raised some of the most important and difficult questions about constitutional courts. Because if you rank democracies in the world, the ones at the very top mostly don't have constitutional courts, and many of them don't have judicial review. And so this is where, there's an old joke that's usually told in Ireland about a person who's, wandering around in the countryside, and he asks the first person he comes to and says, "How do I get to Dublin?" And the person he asks says, "Well, I wouldn't start from here." Right? And so there's the same problem in constitutional systems, right? Which is that many of the democracies that do the best are the ones that have the longest traditions and the deepest cultures. So how do you generate a couple hundred years of culture at a turning point when you're drafting a new constitution? If you don't have the luck to start with a culture, then how do you get one? And I think that constitutional courts are one of the ways that you can get a constitutional culture more quickly. I mean, the main positive example is, of course, Germany, and even in Russia, where I worked at that court, seeing what they do, however awful Russia is, it would be a lot worse if it weren't for that court, actually. And it has done a lot of work, not the big visible cases it has no chance on, but the subterranean cases, minor rights cases, the government knows it has to keep that court on side. It's actually contained it a little bit. Okay, so not perfect. So I think constitutional courts, because they have this visibility and because they have this political responsibility, and because the judges are not there forever, right? If the court gets off to a bad start, you can refresh it more quickly than a Supreme Court. For all those reasons, it seems to me that constitutional court can become a kind of focal point for creating a new culture. And that's when you get to the really tough issue that you raised about interpretation, right? So one thing that constitutional drafters can do is they can specify how interpretation should work. Now, they can't say, if they want to answer every single question a court would get, a constitution would be 1,000 pages long. So not to do that, but for example, to say that for example, that the decisions of the Chilean Constitutional Court should be consistent with the decisions of the Inter-American Court on Human Rights, for example, which Chile is a part of. That could be an anchor. It could also be an anchor to say that the decisions, and this happens in, Canada and South Africa, for example, there's a clause in the Constitution that says that the decisions must be justifiable in a free and basic democratic order. Right now, you could say free, basic, and secular democratic order. You could, in other words, that interpretive clause in the Constitution can be crafted in such a way so that it doesn't permit sectarian interpretation, or doesn't permit interpretation that only favors one side of a well-known political divide in the culture, right? In other words, you should figure out how to interpret the Constitution in such a way that it's justifiable even to those who disagree with the decision. So if you're worried about polarization and decisions that don't reflect the majority, then another kind of strategy is to require a supermajority on the court for overturning a statute, right? So instead of a simple majority, you could require 2/3 of the judges agree to nullify a law. A simple majority can interpret a law, but to nullify a law may be a higher standard. So that way you need more agreement in the group. Another way to do it is to do, again, what the Germans do, which is really kind of remarkable that it's worked as long as it has. They have a kind of agreement. It's a political agreement, not in the law, that the German Constitutional Court will always be evenly balanced between judges on the left and judges on the right. They have 2 senates. The senates have even numbers of judges. Usually we think you need an odd number so somebody breaks a tie. But if you create an 8-person court, which Germany has, 2 8-person courts on the Constitutional Court. One deals with separation of powers and international law. The other one deals with individual rights. And then you have an agreement that 4 of those judges shall be affiliated with left-leaning parties and 4 with right-leaning parties on each bench. It means that any majority has to pull somebody over from the other side. And that actually generates decisions that can generate more political consensus. So you can do things like that structurally in such a way that it makes it less likely that the interpretations will look like they represent only a particular faction of the society. I think sometimes, this old procedure they used to have in Hungary before Viktor Orban got rid of it, where a nominee to the Constitutional Court needed a majority of political parties behind him. There were no women at that stage, but each nominee needed a majority of political parties and then a supermajority of members of the parliament. That screened out the candidates who were controversial pretty well. So again, structure doesn't solve everything. As I said at the beginning, a lot of this is culture, but you can try to get the culture launched by getting the structures right, and then hope that you've got judges who will rise to the occasion and actually stand in defense of the Constitution and its values, rather than the values of wherever it is they came from with their PhDs.
Javier, ¿quieres agregar algo?
Sí, no, me parece muy interesante
A really interesting idea of how the institutions can launch a culture. I just had one little comment on something that you referred to, which I believe it's quite relevant. You said that civil law countries such as Chile, you have constitutional court, which is not the Supreme Court that will act as that will nullify law. So one of the things that we have seen in Spain, but also in Chile, a couple of years ago actually, was this actual clash. The Supreme Court would sort of disobey a decision of the Constitutional Court, not necessarily in something that would affect democracy, but that would affect the authority of the Constitutional Court in a sense. And some would say that so the rulings of the Supreme Court would be reviewed by the Constitutional Court so as to sort of close. See, there was a lot of rejection, and there is some sort of a status quo. But same thing, we have seen the same thing in Spain. What would you say is the institutional design? Is it better to just keep things in that some sort of a status quo, or to give the Constitutional Court the role of acting as a referee in terms of interpreting sometimes the rulings of the Supreme Court?
Kim?
Yeah, so it turns out that in many systems where you have a new constitutional court brought into a judiciary that's not used to it, there are very often conflicts between the Supreme Court and the Constitutional Court. That happened for a while in Hungary when I worked at the court. And the way that it got resolved was that the president of the Constitutional Court invited the president of the Supreme Court over, and they started having regular meetings because they're on the same side. You know, you think maybe it's, you know, it would be a conflict of interest if the president of the Constitutional Court did that with the president of the Republic, okay? But this is, you know, it's a judiciary with two pieces. And it's not a bad thing for the presidents of the courts to get to know each other and also the other judges. So there would be these regular meetings, you know, between the Constitutional Court and the Supreme Court judges, and sometimes judges of the other courts. And one of the things that did was to build a sense that they were all in the same legal system together. And what the Constitutional Court could do was often defend those courts from political attacks. And in exchange, those courts, like if there was a case where the Supreme Court thought the case was too hot to handle, right? It was a very controversial case. They'd send a reference, right, to the Constitutional Court instead of deciding it and having the Constitutional Court overturn it, right? Or they would decide the case in the Constitutional Court because they'd all sort of been in a conversation behind the scenes. The Supreme Court would know the Constitutional Court would back them up. So they would often discuss these issues the way a collegial court would. You just think of it as a very big collegial court with the Supreme Court and the Constitutional Court sort of working together. And that really straightened things out. And so I think that that's, you know, a lot of this is personal conflict. And if you can overcome the personal conflict, then often the judicial conflict goes away as well. So I've seen that happen. It's also just a matter of the Supreme Court learning, like the Constitutional Court has to be predictable. So the Supreme Court can't make a decision believing that the Constitutional Court would say one thing and then the Constitutional Court overnight changes its mind. Okay, so that also helps if the Supreme Court has a you know, a sense. One thing I did in Hungary, because the court was very new, I mean, I got there, the court was 4 years old when I got there, was I was surprised that there was no regularized way for the ordinary judiciary to learn about the decisions of the Constitutional Court. So they violated them not because they intended to violate them, but because they didn't know what they were. So I led a group at the Hungarian Constitutional Court, and we made the first ever case book of constitutional law. And then we went around the countryside and we published the book in great quantity so that every single judge in the system had one of these. And then we went around to all of the regional courts and did these seminars with sort of sample cases where the ordinary judges would have a chance to think through the constitutional questions after they'd read the materials. And we, you know, like a US casebook would excerpt these long decisions, we'd boil it down to a few paragraphs. And we organized it not by section of the Constitution, but by area of law. So family law cases, criminal law cases, so that an ordinary judge would know which decisions of the Constitutional Court were relevant for substantive areas of law. And that also really helped overcome the gap between the ordinary judiciary and the Constitutional Court.
Kim, me llega una pregunta del profesor Rodrigo Correa
Kim, I got a question here from Professor Rodrigo Correa
de la Universidad Adolfo.
From University Adolfo Ibáñez. So it basically says the following. I think that in the end, this whole thing regarding constitutional courts as defenders of democracy is based on an assumption that the lawyers can contribute with rationale to politics. But that assumption also lies or rests on another assumption, that we lawyers have certain consensus. And nowhere in the world are lawyers in agreement on if women have the constitutional right to abort or not, for example. So how would you address this issue?
Yeah, it's a really good question. So constitutional courts don't necessarily need complete consensus, and they won't get it because there is no consensus in the society as a whole. If there were, then there would probably be no cases that come to the Constitutional Court. So the question is, how does the Constitutional Court give meaning to this Constitution, right? They're not telling you their personal views. They're trying to tell you what this Constitution means. And, abortion is one of the most difficult questions in any legal system. In fact, I used to teach a whole course on the comparative law of abortion because it's one of those areas where courts across many different countries do very different things. But that's the number of cases where that's true, where you get a court in one country deciding X and the country in the next country decides not X. It's a relatively small number of constitutional questions. And those are the hard ones, and those are the ones that for which there's no good answer, I think. But over a great many questions, how should prisoners be treated in jails? How should, can the president take over a lot of the functions of the parliament through a decree power? What are the limits to states of emergency? Can they be open-ended or must they have closed dates? Those kinds of questions, there are pretty well agreement across a lot of different constitutional courts. And that's going to be probably, in the constitutional courts I've looked at closely, that's 90% of the cases, which isn't to say there's not disagreement. Okay, there will be dissents and so on, but there is very often a kind of international consensus among countries that have liberal constitutional orders. And by liberal, I don't mean left wing. By liberal, I mean rights-based systems of limited government, right? Where there are things government isn't allowed to do. And where there are checks and balances, a system organized like that. It turns out when you look across different countries, you do find much more consensus than you think you would. That's one of the reasons why I teach comparative constitutional law, because Americans are not all that used to looking anywhere else, and it would help them if they did, I think. And this is, especially for a country like Chile, because you have one of the world's largest languages, because you have so many legal systems that are founded around common, a sort of a common historical background. And frankly, because you have so many disastrous cases, as well as so many cases that have been pretty good, right? You have a big range of experience to draw from. And I think that also is a kind of guide. I mean, you can look at the countries that have done very badly and ask how to prevent that, where did things go wrong? And you can look at the countries that have done reasonably well and to ask, what have they had going for them? And this too is where, the inter-American system may actually be a pretty good anchor, at least for some rights-based questions, because it gives you a kind of view even from outside your own system, both because I think that court is trying to develop a kind of continent-wide understanding about the meaning of rights, right? And also because a lot of the judges on that court come from different countries and therefore have to figure out a way to work together. It's a good kind of model for thinking about how to get some kind of consensus. So I think that, you know, if a constitutional system were easy, the world would be full of successful constitutional systems. And what we see, especially now, because we're in a time of democratic decay, you know, and democratic backsliding all over the place, we can see how challenging it is. But you don't get a success if you don't try. And you have actually, it's been very kind of refreshing and remarkable to watch what Chile has done so far, both in the referendum to create a constituent assembly, and then in the election, which actually rejected the political parties that have dominated the scene, right? So this is a way of saying the public is ready for starting over with a different constitutional culture. There is no better place to start, right, than that. So yes, there are going to be issues, and yes, there are going to be problems. But I think that my sense is that this process will produce a constitution worth defending. And then the question is, what are the institutions that will defend that constitution? And so part of the reason why I have such faith in constitutional courts is not because they're perfect, and we certainly have lots of examples of ones that have failed, but because more than any other single institution, they've really brought a lot of countries from dictatorships and from bad pasts into better futures. And we've seen that over and over again. But again, you can't put everything on a constitutional court. You have to think about how to create institutional redundancy so that other institutions also work with the Constitution and with the Constitutional Court. And the best protection of a democratic constitutional order is to have democratic constitutional citizens. And this constitutional drafting process is going to be a way to create defenders of the Constitution who can stand behind these institutions. So again, it's, you know, it's scary to kind of step into a new political order. But, you know, what you've seen so far in the process that Chile has constructed is just admirable. And, you know, I have a lot of hope for this process. And I have a lot of hope for the people who are going to be thinking these questions through. And I know you've had a lot of polarization, and I know you've had disappointments with your constitutional institutions before. You wouldn't want a new constitution unless you had those disappointments. But you also have a country where everybody said, let's not just have a coup, right? Let's not have a revolution. Let's do this in a constitutional way. And that already gives you a great advantage.
Kim, nos quedan muy poquitos minutos. Tengo una pregunta.
Yes, Kim, we have only very few minutes left, but I've got another question here from Professor Sebastian Soto from the Catholic University. And the question goes as follows. You have said during your presentation that constitutional courts can facilitate the consolidation of a new constitution by declaring the old law as unconstitutional. Should it not be the Parliament, the Congress, the body that's best equipped to declare laws unconstitutional and therefore to have a better transition between the old and the new constitution?
Well, so first of all, I think you tried that once before, if I understand Chilean constitutional history. The problem with parliaments declaring old laws unconstitutional under a new constitution is that a new constitution usually needs to be accompanied by a lot of new laws to fill in things that the Constitution has not yet said. So you need a lot of new lawmaking. The Parliament's going to be busy if this Constitution works, and it won't have the time, and it may not have the expertise to review the entire legal order that preceded the new Constitution and figure out what's inconsistent with the new Constitution. In fact, I saw this in Hungary. Now, of course, that was a much bigger transformation, right? From a Soviet-style command economy to a liberal, economic free market and constitutional and democratic order. But it took the Constitutional Court deciding hundreds of cases a year, probably 7, 8 years before they really figured out all of the changes that had to be made in the prior law to make it consistent with the new constitution. So I think that when you have this kind of change, the parliament's going to be busy trying to fill in the constitutional order with laws that the Constitution may require. And it will be too much work for the parliament to also do the cleanup. Now, you know, again, you can design this process in a lot of different ways. I mean, one thing you could do is for old laws, you know, say that the Constitutional Court takes the first draft, you know, and says these laws are unconstitutional. And maybe for those you'd want a parliamentary confirmation, you know, not in general for the new laws, but on the old ones. You can build that process in a lot of different kinds of ways. But my guess is that, you know, the members of parliament are not all lawyers. They don't see sort of technical conflicts, many of which will be purely technical, right? And something hard for non-lawyers to see. So you may want expertise to be able to go through and sort this out, but maybe you want to put in something like the parliament needs to confirm that old laws, you know, are to be voided. You could do that too. Again, there are forms out there, but you can also invent new forms. The problem is, I think, that lodging the judgment of constitutionality with a parliament makes it much more political than legal. And it needs to be more legal with a little political, rather than very political with a little legal, if you see what I mean. That this is something where I think you want some expertise and the ability to justify why certain laws are consistent with other legal provisions, namely the Constitution. So parliaments are not very good at that, and you need explanations. And parliaments are really not good at arriving at single explanations, which I think is what you need in this circumstance.
Muchas gracias, Kim. Vamos a cerrar.
Well, thank you so much, Kim. We're going to be closing this here. We're right on the dot, but we will carry on for a few more minutes. I believe that Javier has an additional question, so we can carry on for a few more minutes, but that will only be on the uai.cl platform. So if you want to continue with us with this conversation with Kim Scheppele, please then go from the EMOL side and go to the UAI side. Thank you so much, Kim. Thank you, Javier. Thank you, everybody, for paying attention to us. Good evening. The next seminar will be on next Thursday at 6:30. You will get the invitation, and I will not spoil it for you. We will let you know what it's all about. But it's next Thursday, the 24th at 6:30. Thank you so much, and we will see you then. Good evening, good night.
Estamos fuera.
¿Estamos en la UAI ahora?
Sí.
Javier, entonces te paso la palabra a ti.
Sí.
Okay, Javier, the floor is yours then. Kim, thank you once.
Lleno de información y llena de muy buena.
This has been full of information, and I really liked this last idea that you just gave on how there's a head-on train collision here, but that it can be solved with a better partnership approach. But there's something else that I want to talk about. The Constitution does try to have certain consistency. It must be a system. It cannot have parts and bits that don't fit. I remember that once I had to evaluate these, there were models of democracy, participative democracy, like in Sweden or Uruguay, which in Latin America is the one that most uses referendums. And there's something that's a little incompatible here when there's a decision that goes against, I mean, when the people have
de una manera categórica. O sea,
categorically, then I can understand why Sweden does not have a constitutional court or does not make a decision against that. And the case in Uruguay is very similar. And in Chile, well, the political parties have a very lack of prestigious, and it's mostly based on direct democracy, but not really a representative democracy. And this is something that in a certain sense can also be a contribution. But what do you think about this interaction between the Constitutional Court, but also referendum, national referendum mechanisms? Because culturally and historically, there's a certain tension between these two.
Yeah, so I completely agree that there's a tension. But again, you know, I don't want to always say that good design can solve everything, but good design can help. So in Hungary, there was a referendum procedure, but the Constitutional Court decided on the questions. So people would propose questions and they came in like cases to the Constitutional Court. And the Constitutional Court would decide whether it was the kind of question that could go to a referendum or not. So early on, the Constitutional Court said, you can't amend the Constitution by referendum, you know, but there can be a referendum on constitutional questions that is advisory to the Parliament, which has the capacity to amend the Constitution. So the Constitutional Court laid out a series of rules that allowed referenda to go forward, but didn't just, you know, kind of throw a rock through the window of the Constitution, right? So you have to figure out how to make referenda compatible with the rest of the legal order. So one of my problems with referenda in general is that they tend to be, and probably they should be, on single questions, you know, so should gay marriage be allowed, for example? Now, some kinds of single questions are just single questions. So should gay marriage be allowed will require changing the marriage law. It may require thinking through some other rights issues, but it doesn't fundamentally affect big chunks of the Constitution, right? But if you have a referendum on, you know, should there be a personal income tax? Okay, then you have a lot of interested citizens who would love not to pay taxes, but the consequences of that for the entire system of government is enormous, and the citizens aren't asked to think about the trade-offs, which there will be with a question like that, right? So some kinds of questions lend themselves to referenda because if you get citizen input, you can integrate that into the legal order without disrupting the whole legal order. Whereas other kinds of questions really completely mess up government, right? They defund the whole government, or they create conditions that can't be met. So I think that the referendum has a place. And I kind of liked that system in Hungary where the Constitutional Court had the final decision on what questions were the sort of questions that a single issue referendum could decide. Other questions involved really rethinking the whole structure of government, and the Constitutional Court would typically refuse those. So I think you can do it within limits.
Tengo aquí otra pregunta del mismo profesor Soto.
Again, a question from Professor Soto.
¿Cree usted que es un problema que
that could be a problem
puede afectar la legitimidad de las cortes constitucionales?
Affect the constitutional legitimacy?
Que se pueda predecir las votaciones de sus integrantes.
That you can actually predict how the members will vote in the Constitutional Court?
Por ejemplo, si pensamos en la Corte Suprema de Estados Unidos,
the Supreme Court in the US,
uno puede adelantar que Alaito va a fallar de una forma y Sotomayor de otra.
Sotomayor in a different way, right?
¿Afecta eso la
Will
legitimidad de
that
la,
affect the
la
legitimacy
sentencia o no?
of a ruling in a way?
Such a good question. So actually, one of the things that I often like about the German Constitutional Court, and it was also true about the Hungarian court and the Russian court and many other, the French court, is that the decisions of these courts are not signed. So you don't actually know who wrote them, and you don't actually know necessarily who voted for them. So, for example, in Germany, where each panel of the Constitutional Court has 8 judges, the court guarantees to you that there were at least 5. Okay, but there might have been 3 dissenters. In Germany, however, you only write a separate dissent, and dissents are signed. You know who wrote them. You only write a dissent if it's really an important point that you believe needs to be made publicly. So the dissents are not very often, even though unanimous decisions are also not very often. But what you get is a decision of the court itself. Now, the reason why, and of course in the US Supreme Court, you know the names of the judges and how they vote. Everybody knows the names of the judges and how they vote. The problem when you have named judges writing opinions is that Justice, well, I won't take a certain one from the court, but let's say Justice Smith, not a current judge, feels like he has to develop the Smith theory of everything. And then what that does is it means that he's writing for himself, right? He's writing for himself and his fan club, and he's not writing for the institution. You know, what matters in constitutional law is that you understand how the institution will decide. And if you don't understand how the institution will decide, then it's very difficult for the other branches of government to actually understand what constitutional law is. I remember doing some interviews again in Hungary in the 1990s, and there was one particular line of argument that the Constitutional Court was developing where it wasn't very consistent. And a member of parliament said to me, it's like driving down the road and the Constitutional Court is coming at you like a car without its headlights. How do you avoid it if you don't know where it's going, right? So the court needs to be predictable at the level of the institution for the other institutions of government to be able to work with it. And in fact, I stopped teaching US constitutional law 20 years ago. And the reason why I stopped was that I could no longer predict what the court as a whole was going to do. And how can you teach students if you don't know what you're teaching them? It's very difficult to teach constitutional law in the US. Today, there was just a decision of the Constitutional Court, of the Supreme Court in the US, upholding the Affordable Care Act, the so-called Obamacare law, when everybody predicted it was probably going to disappear today, and it didn't. 7-2, who could tell, right? So we're now in a situation in the US where, because of the fact that every judge is playing to their own audience and signing their name, you cannot predict what the aggregate will do. So I'm actually in favor of constitutional courts having unsigned opinions so that a judge can do something in one case and something inconsistent with his own personal view in the next case, as long as overall the court is making coherent and consistent decisions. If it isn't, then it generates cynicism, and it generates, well, other institutions can't obey court decisions if they can't actually guess in advance what they're likely to be. So I hate signed opinions, and I've talked to some of the judges on the US Supreme Court about this. Unfortunately, I don't think this can be changed, but you guys can change it in your constitutional court.
Javier, ¿quieres agregar algo?
No, yo nada más quisiera decir que
Just to
efectivamente.
say that this is like, it's a comment, really. There are several local issues so that your insights, Kim, your recommendations, Kim. In Chile, we have, I'd say, the burden of the concept of a constitutional court will be heavy. That is, this Court was designed to protect an economic model. This was acknowledged and recognized by the ideologue of this constitution. He put it in writing, quite in the open. This constitution is intended to force Democrats, dissident Democrats, will do what we would do. So it was a partisan, it was a vision. And when the appointed senators was deactivated, and the first government, the first administration tried to disband some of the elements of a certain constitutional clauses that were highly neoliberal. I believe that, I mean, it's been said that going to the Supreme Court in Chile, we have this situation. Now, some of us question that the Supreme Court would be highly politicized, and this is not the case, because who violates the fundamental rights in Chile and in Latin America is the executive, not the legislative power. And when the Supreme Court will turn down unlawful executive actions, the partner is the Congress. But when a court nullifies a law, opposes both branches of the other two branches, the executive and the legislative power, and then you need quite support. And in Chile, I believe we have the preventive control damaged this quite highly, and the president appointed a very close individual everything that you could do wrong, as to many of your recommendations, were actually done wrong, and that will make the situation very challenging. Changing the name, it was one of the absurd recommendations. Lawyers actually support this type of court. There is a constituency of lawyers that will support this court. But if we need constitutional justice, that should be held by the Supreme Court, and we still have to see what will be that strategy. We have very few, actually 2 minutes left.
Yeah. So I guess what I would say is that if you think the Constitutional Court is political and stuck in an old model, wait till you see the Supreme Court, right? Judges have life tenure at the Supreme Court. They will not change anytime soon until they hit a retirement age. Judges on a Constitutional Court typically have terms of office that allow them to rotate. That's what makes the Constitutional Court more politically accountable and responsible than a Supreme Court. Okay, so I think that's one reason why I favor sending a lot of these questions to the Constitutional Court. Now, I know that there's been a controversy about a number of the Constitutional Court rulings in Chile because of the neoliberal, shall we say, tilt of the present constitution. Here's where an interesting cautionary tale or an interesting example from India, I think, is useful. In India, the Constitutional Court, or the Supreme Court there, was defending the right of private property against all the efforts to make a more social state. It was one of the reasons why Indira Gandhi declared an emergency in the 1970s. And while the country was under a state of emergency, the Constitution was amended to take out the right of private property. Same court, end of emergency. They were eager to show that they were active and enforcing the Constitution. They flipped entirely to a social democratic court, the same court, because the Constitution had changed. So it may be that if the economic model that's hardwired into the Chilean Constitution becomes a different economic model, the very same judges may change. Now, I don't know them personally, although I met some of them when I was last in Chile. I don't know anything about this, right? But what I've seen is that judges that follow the Constitution change when the Constitution changes. They're supposed to. And if they're good judges, they'll do that. So that may be one thing. The other thing is that, I was talking about nullification of laws, and that raises the most challenging exercise of judicial power in a democracy. But in Hungary, I guess the phrase would have been normative acts, not just statutes, but decrees. I mean, courts really have to be able to look at decrees, and they have to be able to look at administrative decisions. So as the jurisdiction of the Constitutional Court is being defined, it would be absolutely crucial for it to review in real time, especially in a presidential system. If Chile is going to maintain a presidential system, the Constitutional Court has to be able to look at lawmaking in the executive branch and not just at statutes of the parliament. So again, this is another way the jurisdiction actually needs to be modified. So, I think a lot of what, as I understand it, the move to change the Constitution is about in Chile is the desire to be a different kind of society. It's a good reason to change the Constitution. And it's a good reason to think about how that new society can be defended when it's new, right? The challenge, and Javier, you're a socio-legal scholar and you'll understand this completely. It has to go from paper to reality. And the question is how you get a document out of a constituent assembly and make it real in everyday life. And that's where it often helps to have an institution like a constitutional court that provides a focal point for the kind of announcements about how this new constitutional order works. And so if it's just diffuse, if everyone is trying to figure it out by themselves, if you have courts all over the country making pronouncements that are not written down and made public, as decisions often are not in civil law systems, how will anybody know what this new constitution means, right? So having a focal point and having judges who take responsibility for making the Constitution real in everyday life is a way to accomplish that goal. And I've seen it happen, in Hungary, it was a reasonably smooth transition. In Russia, it was very bumpy. But, when Yeltsin called out the tanks and stopped the Constitutional Court came back and told him no. It was really remarkable. And actually, the president of the Constitutional Court, who was still the president, he was not president, he's back again. But, literally, the security services came into his house and shot his cat, just to tell you how bad it got for the judges. They didn't shoot him, but I have a cat. This would be a serious issue if somebody did that, right? So these judges were intimidated. They still kept acting. You need judges who are brave and who will stand up to assaults on the constitutional order, and they need to be backed by citizens. So, I'm kind of optimistic because the citizens have spoken, and at every turn, they've made an overwhelming choice for a new direction and for an independent body to set them on the new course, right? So I just, I'm going to watch this with great interest, and I really do have a lot of hope for this process, given what the Chilean public has done already.
Thank you very, very much. Muchísimas gracias, Kim. Ha sido una oportunidad extraordinaria.
Thank you so very much, Kim. It was an amazing opportunity. It was a comprehensive presentation, addressing lots of issues, lots of topics, something that it's still turning around here. It will be ever present in all the discussions in the drafting of the Constitution. Thank you very much for your contribution, Kim. Thank you, Javier, for your excellent comments and questions. Thank you all, and have a good night.
Thank you. It's great to see you. I hope in person soon.
Me too. We all.